The Senate is adjourned. Sine die.
All those in favor say aye. Aye. Those opposed say nay. I'm surprised. The motion passes and the House is now adjourned. Sine die.
There it is, sine die. And on the 94th day, they rested. The 2024 regular legislative session is in the books, with hundreds of new laws now on the books, from funding school facilities to extending contraception a few more months to preventing people from using preferred pronouns. And coming soon, Idaho libraries will soon be able to be sued over what books they have on their shelves. Governor Brad Little ended the mystery of will he or won't he this morning by signing House Bill 710, the Children's School and Library Protection Act. This bill, now law, gives parents the means to file a complaint with a library about a book they find objectionable in the kids section. The library has 60 days to relocate it, or if they believe it's in the proper section, they can leave it there. And a parent can then sue for $250 and other damages, with no limit on those other damages. So libraries have until July 1st to figure out what they're going to do with any material some might consider questionable. And it's a long list filled mostly with books with LGBTQ+ subjects. Do libraries remove all such books completely? Do they just block off sections of the library? Or do they install cameras to make sure books aren't mistakenly placed in the wrong section? Those are all things we've talked about while covering this topic over the last 3 legislative sessions. House Bill 710 was the 5th attempt at regulating library books. And despite the overwhelming numbers of Idahoans asking the governor to not sign it into law, 7,150 emails and phone calls versus 4,251 in favor. Despite those numbers, Governor Little made it law. In his transmittal letter, Governor Little wrote, House Bill 710 this year addresses most, but not all of the concerns he outlined in his veto letter last year, pointing out the drop in bounty from $2,500 to $250 and the 60-day time frame for librarians to address a concern. Most, but not all, could mean the first sentence of the 3rd paragraph from last year's veto explanation. About House Bill 314, he wrote, my main concern is that the bill's ambiguity will have unintended consequences for Idaho libraries and their patrons. This legislation makes sweeping blanket assumptions on materials that could be determined as, quote, harmful to minors, end quote, in a local library, and it will force an interpretation of that phrase onto all the patrons of that library. House Bill 710, Governor Little wrote today, tightens the definition of what is considered harmful to minors. Does it, though? Because under the section harmful to minors, this year's bill contains the exact phrasing as last year's bill, word for word, from definitions of obscene materials to what is harmful to minors, which includes any act of homosexuality. Both bills even contained some semblance of the Miller test, which is what the Supreme Court said should be used to determine whether something is obscene or not the I know it when I see it definition. Critics point out House Bill 710 only includes 2 of the 3 prongs of the Miller test. The appeals to the prurient interest, the depictions or describes are patently offensive, but not the taken as a whole lacks value thing. That part was kind of, well, hidden in the bill, if included at all. So the ambiguity of the bill having unintended consequences, as Little wrote last year, the sweeping assumptions on what is harmful to minors, what one parent considers harmful could determine what you consider harmful. Governor Little's main concern from last year's bill, those things didn't change, like at all. Governor Little wrapped up his letter of explanation with this. Like many Idahoans, I'll be watching the implementation and outcomes of this legislation very closely. Critics and librarians have already made it clear implementation will be difficult, and the outcomes, well, they're going to likely be less access to some literature.